Hello, my name's Liz Ward and I'm an intellectual property specialist, a solicitor with 30 years experience of IP disputes. And in my time, I've seen lots and lots of different matters which have gone all the way to court or become very, very contentious indeed. But one that crosses our path fairly regularly is actually breach of confidential information. And that can happen in a number of ways. But one way that we see quite commonly in our practice is where somebody who's been an innovator or has come up with ideas, come up with formula, come up with new ways of constructing something or new ways of manufacturing something or a new product formulation, whatever it is. And then they go out to a subcontract manufacturer and they say, here's my idea. Well, rule number one, always disclose this kind of material under a confidentiality agreement. Rule number two, make sure that everything that you provide has not only got your confidential stamp on it and it's marked as secret, it's marked as confidential, but it also has your copyright notice on it. So they're on notice of your copyright. And number three, make sure that you both agreed what will happen in the end. Are you having this relationship with a subcontract manufacturer because you want them to manufacture your formulation or your particular product according to your particular kind of method of manufacturing? Because it's quite common to see, unfortunately, disputes arising around this area where perhaps you disclose to a manufacturer some confidential material that shows just how good something can be made or how well something can be made or how advanced something can be made. And the problem with that is if you're the innovator and you're on a limited budget, the people with the deep pockets here to run off with your idea and do what they want are the manufacturing entity. So be very, very aware of it and extremely conscious of disclosing that material, particularly to overseas manufacturers. But even here in the UK, people can be bad actors. They can see a great idea, they can see a great product, they can see a great manufacturing technique, and they can go off and do it. And they'll often have deeper pockets than you when it comes to protection. So what can you do to protect yourself? Well, have written agreements for sure. That's a non-negotiable. Have your copyright notice on everything. That's a non-negotiable. But the other thing you can do is make sure that you've got a war chest. Make sure that you are well equipped if there is any kind of a dispute. Even get legal expenses insurance to cover what might happen if somebody does the dirty on you and uses your confidential material. The other thing that you can do is go in early where there's a threatened breach of your confidential information. If you've got the deep enough pockets, is to apply to the court for what they call an interim injunction. That's an injunction where you go off to the court and you go, Mr. Judge, stop them from doing this. Stop them from manufacturing a product to my specification, to my manufacturing techniques. But there's no other way around it is to have some money behind you to enforce it. Intellectual property rights are great, but they're enormously expensive to enforce. So make sure rights on your side, make sure you're insured, make sure you've got witnesses, make sure you've got a really good audit trail of actually what's gone on. I hope that's been useful. Thanks for listening.